And our next case will be 23-1239 Olczyk versus Parenti. All right, everybody ready and set? Okay, we're ready to proceed.
May it please the court. Good morning. I'm Lindsay Lawton, here on behalf of Brian Olczyk and the law firm of Garrison, Yount, Fort, and Mulcahy. And I'd like to reserve 5 minutes for rebuttal. We're here because the trial court sanctioned Mr. Olczyk and his law firm on its own motion when Olczyk asked 2 questions that the court found to be in violation of a ruling on a motion in limine. The sanctions order in this case is unprecedented in 2 ways. First, there's no case that I've been able to find or that my opposing counsel has found where a court imposed sanctions for conduct on this level. Second, there's no case that I've been able to find or that my opposing counsel has been able to find requiring an attorney to send a letter to clients, essentially warning them against using that attorney's services. That sanction is extreme and severe and a big deal. And that's the big picture of this case. We've raised 5 issues in the initial brief, and of course carried them through to the reply brief. The first is that the trial court abused its discretion in finding that sanctions were warranted at all for this conduct. Second, the trial court lacked authority to require Mr. Olczyk to send a letter out to clients and insurance carriers, warning them against using the firm's services. Third, even if that authority could be found, the sanction is far out of proportion to the conduct. And then issue 3 is specifically about the sanction requiring the letter to the clients.
You're not disputing that Mr. Olczyk didn't violate the motion in limine, though, are you?
Yes, Your Honor, I am disputing that Mr. Olczyk violated the motion in limine. The ruling. If you look at the language that the trial court used in expressing what the ruling was, it was all about lawsuits, not insurance claims.
But didn't Mr. Olczyk, he specifically asked this question to clarify this with the court, can I ask about claims? And the court said no. How is that not clear?
Because, Your Honor, when Mr. Olczyk asked that question, it was at the end of a discussion about lawsuits and litigation. And to the context of his use of the word claim was a legal claim.
So wouldn't it have been better for him to come up to sidebar, ask for reconsideration or something like that?
It certainly would have been better. I think that's, as Mr. Olczyk said in his motion for reconsideration, that's very clear, especially in retrospect.
When was this motion in limine hearing? Was it the day before?
It was. It was right before jury selection.
Should have been clear on his mind, correct, of what the judge's ruling was?
It would have been clear that the court made a ruling and what the ruling was, yes, Your Honor. But what I think was not clear to Mr. Olczyk, as shown by his response to when the court called a sidebar, is that it was not clear to Mr. Olczyk that the ruling covered insurance claims. In fact, Your Honor, if you look at the sanctions order, even the court never said in that order that the ruling extended to insurance claims.
I agree with you that if that one question hadn't been asked by Mr. Olczyk, and we can't, for clarification, we can't ask if Ms. Parenti brought claims alleging permanent injury, and the answer was no. If that wasn't there, that'd be a swell argument. But I was a trial lawyer for a long, long time, and if a judge said you can't talk about claims, if you got to the point where you thought you had an open door after the judge told you no, you can't mention claims, it's not up to the lawyer to say, you're wrong, I'm doing it anyway. You can do it, obviously it was done here, but that's not at all the way to go, and I don't know any court that says it's okay for you lawyer to rule on your own objections.
I 100% agree with you, Your Honor, and I think Mr. Olchik agrees with that too. And even in his discussion with the court, he didn't say, I thought it was okay for me to violate the ruling. In the motion for reconsideration, he did say, I thought that the door was opened. But I don't think there's any evidence in the record that in the moment his intention was to violate the court's ruling. Again, his response immediately when the court called the sidebar was, I was referencing an insurance claim. And I understand that the question Mr. Olchik asked the day before for clarification complicates the analysis and makes it appear that, I guess, gives a more reasonable.
Hold on just for a second, and I'll stop your time. What's that noise I keep hearing? Does anybody know? Is there a bird in here? Or? What's that? On the roof. Oh, okay. Sorry. That's a first for me as well. New pretrial order, birds on the roof. Okay. Sorry.
Thank you.
Go ahead. Now, I'll give you a second to collect your thoughts. Go ahead.
I appreciate it. So I guess what I was saying was I understand that the question Mr. Olchik asked about, does this, for clarification, we can't mention claims. I understand the argument that that should extend to all claims, but I think the problem we have here is that the word claim is versatile. And, most of the time when lawyers are talking about claims, they're talking about causes of action. And that was the context in which that question was asked. And
how do we know that?
Because if you look at the hearing that was held, the morning of jury selection, repeatedly when the judge is talking about what's excluded, he says lawsuits. He says litigation. Litigation isn't filing an insurance claim. Litigation is filing a lawsuit.
Well, didn't he ask, we can't ask if Ms. Parenti brought claims alleging permanent injury? Isn't that insurance claims?
He did ask that question, Your Honor, and
the court said no.
The court did say no, without elaboration, to say no, you can't reference insurance claims, just saying no, you can't reference claims.
So let me ask you this, if an attorney intentionally violates an order of the court which leads to a mistrial, is it an appropriate remedy for the court to award or sanction him with costs? Would that be an appropriate remedy?
If an attorney intentionally violates a motion in limine, a ruling on motion in limine.
And then causes a mistrial, like in this case,
And causes a mistrial.
Are costs an appropriate sanction? Not sending the letter out, but are costs within the judge's discretion?
I don't know of a case that specifically says that a sanction is always appropriate for an intentional violation of an order, but I can certainly appreciate that makes sense. But there's no evidence here that there was an intentional violation. And I implore you, if you're considering ruling that there was sufficient evidence of an intentional violation, please review carefully the discussion leading up to the question about does this extend to claims. That discussion, every time Mr. Olchik talks in that discussion, he says lawsuits, he says litigation. There's no evidence that he had the plaintiff's prior insurance claims on his mind. And again, if that's what he thought, then his defense...
But he made the distinction. He wanted to know, okay, I get it. We can't talk about lawsuits. He asked, can we talk about claims? We may be beating the dead horse at this point, but so if you want to touch on something else, we'll probably let you do that. But again, that's a tough one to ignore. Just telling you.
I appreciate that, and I'm happy to talk about any issues that the court...
Moving on to the authority question. Where does the judge get the authority for the sanctions? Where's his source of authority for the sanctions?
The court, I think it was in denying the motion for rehearing, he said that he was relying on his inherent authority. Okay.
Is that inherent authority plenary but subject to other limitations?
There's no case specifically saying exactly what a court can do in its inherent authority, but there is some guidance from Moakley.
Does the judge need some express authority to be able to issue those sanctions? In other words, does he need some sort of positive authorization for whatever sanction he's getting, or, as you said, is it part of his inherent authority, which would be, as I said, plenary, but then subject to the limitations that come from case law?
I believe it would be plenary subject to the limitations of case law.
So you're saying that this was out of his authority because it wasn't as severe enough as other cases where you've seen judges issue sanctions. Is that our standard, or is it that the judge should be able to issue sanctions unless there is some restriction that we can find in the case law that says you can't do that?
My argument is not that the court lacked authority because there's not another case dealing with these sanctions. It is because when the Florida Supreme Court authorized a trial court to issue sanctions to an attorney, it was based on the court's need to do things necessary to enforce their orders and to prevent the obstruction of justice. And this discussion was in the context of needing...
Those were cases where we were talking about sanctions by way of issuing attorney's fees. Could you issue attorney's fees as sanctions, and then it separated the line between what is contempt and what is issuing sanctions, and there was the dissent that said this should all be contempt. We get all of that. What we're talking about here is the judge's inherent authority to issue sanctions as punishment, which probably are read more in line with his authority for contempt, even if he doesn't speak the words, "I'm holding you in contempt." What I'm asking are simply, what are the restrictions that are placed upon that authority?
The restrictions, and I'm getting this from the Moakley discussion, are that it has to be related to the case in front of the judge. If it's not, then you've got a jurisdiction problem, because the courts can only decide the issues that are presented to them properly through pleadings, typically. In this case, of course, the issue is presented through the conduct that happens in the case. If the court is ordering Mr. Olczyk to do things that are not directly related to what happened in that case, then he's really getting outside of the bounds of his jurisdiction. And
what about monetary sanctions?
Well, monetary sanctions relate to a case. They're always, you're required to pay the attorney's fees for the other side.
What about monetary sanctions for contempt?
Those would be issued after contempt proceedings that occur under criminal rule.
I think we're going to get to your lack of notice and hearing issue, but lack of notice and hearing issue aside, right now just focusing on the authority of the trial judge and the restrictions on the trial judge, I'm not sure that I saw in Moakley anything that said that a judge would be restricted in the way that I think you're arguing they are.
I agree that this is a case of first impression. My argument stems from Moakley and the fact that the courts are of limited jurisdiction. They can only do what comes before them through a proper process. Additionally, we have cases besides Moakley where courts are saying you can't do what amounts to attorney discipline outside of the disciplinary procedures. And this is tantamount to attorney discipline. He's requiring Mr. Olczyk to send letters out far and wide to clients and insurance carriers.
Let's be careful parsing that out. I think those cases talk about not being able to restrict the attorney's practice of law as a method of discipline, not being able to, outside of the procedures that are outlined, being able to basically take their license. The idea of amorphously then calling that discipline and saying that a judge isn't allowed to affect discipline, are you asking us for an expansion? Because I don't think the cases go quite that far.
I'm asking primarily that you find that a court's sanction authority is not unlimited. That it is limited to the court's jurisdiction over the case in front of it, that it has to be narrowly tailored to the circumstances that the court is actually addressing.
Counsel, we have seen, as practitioners and from this lovely vantage point in reading all the cases, there are certain attorneys out there who could care less if there's a mistrial, who could care less if attorney's fees are imposed, and if they don't like the jury, if they think things are going south, they're going to mistry the case, and they don't care what it is. So say the judge has Groundhog Day, and every day it's these same lawyers, every day they do the same thing, every day they do a mistrial, every day the judge sanctions whoever that particular time is the bad guy. Does he just have to sit back and let 12 cases go by with these same lawyers doing the same things? Or can he do something more creative? Like here, I mean, I'll quote the trial judge's daddy in the Adams case. He says, while it's suggested these cases should be tried on merits and not attorney shenanigans, the threat of an admonishment in a new trial appears to be of no avail. I mean, in the fourth DCA, they talk about a certain lawyer who's been in front of them, got multi-million-dollar verdicts, they wag their finger at him, and he goes and gets another multi-million-dollar verdict. You know, as Judge Cohen said in one of his concurring opinions, what the courts will permit will continue to happen. So how do you stop it unless you do something like this?
I guess first of all, I need to say that there's no evidence in this record that Mr. Olczyk is one of the attorneys of the ilk that you're describing.
I'm not saying he is.
I think this is important to make sure that that's clear, because that puts what the trial court did here in context. But even with attorneys of that ilk, the trial court can refer them to the Florida bar, and they can go through disciplinary proceedings. And remember, we have cases there's the Parrish case that said that a trial court couldn't even require an attorney to self-report himself to the Florida bar. And I believe it is proper, based on the cases saying that you can't restrict an attorney's ability to practice law as a sanction, to look at this and say, oh, well, are we getting close to that? Or is this a sanction that kind of gets around that restriction on the sanction authority? Telling an attorney to inform all of his clients and insurance carriers who have used his services within the past 45 days that basically they might get in trouble if they keep using the attorney's services is an extreme sanction that it does effectively restrict his ability to practice law.
So again, Judge Bruce Jacoba said maybe if they get the message, the clients get the message, they'll quit hiring him. I agree. That is a potential restriction. Do you want to talk about the due process?
Absolutely. Moakley says before sanctions are issued, notice and an evidentiary hearing are required.
What else would have needed to be done in here? I mean, there was a great discussion there with the judge after this happened. Was there anything else that a hearing would have taken care of?
Yes.
Other than what was discussed?
Absolutely. In the judge's order, he said that one of the reasons that he was finding that Mr. Olczyk acted in bad faith was that Mr. Olczyk looked down at his notes before asking the questions. Mr. Olczyk should have had a chance to explain what he was doing when he looked down at his notes. He might have wanted to introduce those notes into evidence to prove what was going on. He might have been able to call another attorney who had helped him prepare. There's an unlimited number of possibilities as to what could be discussed at the evidentiary hearing. We just don't know what that is because there was not an evidentiary hearing. Other issues that could have been discussed are whether Olczyk has ever been in trouble before, has ever caused a mistrial before, all the types of things that the causal factors go to. And also it's important to remember that when the judge called the mistrial, I mean, Olczyk was blindsided. I think that the record shows that. I mean, he didn't think he had violated the order. And due process requires a chance for someone to at least collect their thoughts and gather their evidence and present it to the judge.
Down to about 3:45 of your rebuttal time.
Thank you. Yes, I was just looking to see if there's anything else necessary to say at this portion of my argument. And so I would just highlight a couple of things, which is that remember that Moakley says that sanction authority should be exercised extremely rarely and with restraint. And this is simply not the case for a sanction based on the Moakley warning about the limitations of the discretion. And other than that, I'll rely on my briefs. And
couldn't anybody who's really ever sanctioned, unless it's run-of-the-mill every day, be able to point to that phrase, though, and say, no, this is out of bounds? It's kind of an amorphous standard, isn't it?
I don't think it is, Your Honor. It sets a bar for it makes sense of the argument that we look at other cases and we see, has a sanction like this ever been issued? Has conduct on this level ever been sanctioned in any decision that we can find? And the answer to that is no, which I think shows that when you apply the Moakley standard, there was no extreme conduct. This wasn't a restrained use of the sanction power. And it is a use of the sanction power that will chill an attorney's ability to advocate for his clients. Especially, remember in the context of this case, he had to walk a pretty fine line. The court said you can talk about the permanent injury, which was highly relevant under the facts of this case. He asked the plaintiff 6 times if she suffered a permanent injury. She wouldn't give a direct answer. And he made a decision in the moment. And even if it was the wrong decision, it was not extreme misconduct. Thank you. I'll reserve the remainder of my time for rebuttal.
Okay, thank you.
Good morning. May it please the court. My name is Chad Barr, and I have the privilege of representing the appellees in this case. Respectfully, I would just like to start out by saying that in the 16 years I've practiced law, I've never once considered disobeying a court's order because I do believe that is extreme conduct. And that's exactly what happened in this case. I was prepared to address the four major points that the appellants brought up in their initial brief. I don't think I need to address really whether the conduct was in violation of the motion in limine. I do think that the court can look at the record and see that the record was not only in violation of the order in limine, but it was intentional. We can look at the arguments presented after.
What's our standard again on that particular question? The judge decided that it was outside the bounds of the motion. Are we looking at that de novo, or are we looking at, what's our standard?
Well, the appellant.
Are we deciding whether or not he violated the motion, or are we deciding whether the judge abuses discretion in deciding whether?
I think the court has to look at, if we're looking at the Moakley case, I think the part of the discussion in that case was whether or not the order was clear. And I don't think we really have an issue. Whether you want to look at it de novo or abuse of discretion, I don't think that the appellees have an issue in that regard, because as Judge Boatwright pointed out, the appellants are the ones that asked the court to clarify whether they could ask about claims for permanent injuries, and claims of permanent injury are necessary in order to have claims for future pain and suffering. So
yeah, but at that point, then the judge makes a decision. You flat out disobeyed my order. You did it on purpose. You're not arguing before the court. You're arguing with the court, and I'm sick of it. How do we judge that judge's decision?
our argument would be that the standard is still abuse of discretion, because you're looking at the sanction issue as a whole. They argued in their brief that whether or not there was a violation was de novo, even if we go with that, I guess the argument still stands that there's clear record support for the fact that there was a violation of the order. Whether or not it was sanctionable, that's abuse of discretion. So here, clearly there's record evidence that there was a violation. Clearly, whether or not it was sanctionable was as an abuse of discretion standard. So abuse of discretion standard is what we're arguing, because the record supports every other finding of the trial court in this particular case.
Our court has required evidentiary hearings in matters like this. Was the hearing that was held, do you think that was sufficient?
You know, I think your question was spot on, Judge, to opposing counsel. What would you have done? What would have been presented? In this case, the appellant, Attorney Olczyk, had 3 opportunities to explain himself to the trial court. There was the hearing outside of the presence of the jury, obviously. There was the motion for reconsideration that he filed before the sanction order was entered, and then there was the motion for rehearing that he filed after the sanction order. Interestingly,
the hearings on those 2 motions you just described?
No, there were not hearings. But what I want to point out is that there was nothing saying this is what you need to understand, Judge. And so the judge is looking at it going, well, you already told me why you did what you did, and it's not believable.
Have sanctions anywhere near this been approved where there was not a hearing?
Well, I would argue that there was a hearing.
Well, you're wrong. There was not an evidentiary hearing. You know, Adams had an evidentiary hearing. Rhodes had an evidentiary hearing. Simone had an evidentiary hearing. Cape Cove Corporation versus Charlotte had 2 hearings. I mean, you know, tell me about the case that there was no hearing required, because there was no evidentiary hearing here.
I understand what you're saying, and I can't point to a case where it says there was a sanction and there was no hearing.
Mr. Barr, maybe if you could describe for us the difference between the due process requirement of notice and opportunity and an actual formal evidentiary hearing. Is notice and opportunity always mean evidentiary hearing, or is there, if you're on notice and you have an opportunity to respond, does that meet the requirements of due process?
That's exactly my point. You don't have to have an evidentiary hearing to satisfy the issue of due process. It's notice and opportunity to be heard. So Mr. Olczyk was notified by the trial court at the hearing that he was going to issue sanctions.
I don't know that we can answer that just quite so blanketly. If there is some other opportunity, and the opportunity you describe as his opportunity to put it in writing into his 2 separate motions, after the sanctions were issued. I don't know if we can talk about the hearing at sidebar as an opportunity if he hadn't been sanctioned yet, but the two motions that he put in, certainly he had an opportunity to argue his case there. So the opportunity requirement for notice and opportunity is arguably met. But is it met sufficiently? It certainly is not the same as actually being able to come in and explain to the judge the way you would in an evidentiary hearing. So I guess the question I'm asking is, how much opportunity are we required to give?
I don't have the answer for to that question, other than I think in this particular case, what we have is we have a judge telling an attorney at the hearing, at the trial, excuse me, you're going to be sanctioned. Immediately, Attorney Olczyk files a motion for reconsideration of the issue of sanctions. And he had that opportunity to put in, this is why I did what I did. And he didn't do that. He didn't say, let me present evidence an explanation, let me present evidence, record evidence, let me present testimony. He didn't ask for any of that. He just said, this is why I did what I did. And then the order came out and it listed out all the sanctions and he filed a motion for rehearing. And again, what they're arguing, and Judge Boatwright, her answer to your question is nowhere in the record that this is what they were going to do at the hearing if there was a hearing. He didn't ask for a hearing. They just said, this is why I did what I did.
Was this part of Moakley overruled? It said, moreover, such a sanction is appropriate only after notice and an opportunity to be heard, including the opportunity to present witnesses and other evidence. Has that ever been overruled?
I would say no.
Okay, so you were wondering how much notice needs to be, what fair notice and opportunity to be heard. The Florida Supreme Court in Moakley said that includes an opportunity to present witnesses and other evidence. Now, I understand you're saying they didn't specifically ask for it, and that could be problematic for them. But in terms of if they had asked for it, they would have been entitled to it, according to the Supreme Court's case, correct?
But there's nothing demonstrated that they.
If they had asked for it, the opportunity to present evidence and witnesses, under Moakley, they would have been entitled to it.
I think our position is much more difficult if they had asked for an evidentiary hearing and said, this is what we intend to present.
Did they never ask for an evidentiary hearing?
I don't believe that they did. I would have to go back and look at their motion.
I thought that they had, and I'm sure, and no offense taken if you not remembered correctly, because I know there's a lot to this case, and perhaps counsel for the appellant can straighten us all out if that's an issue.
But at the end of the day, there's nothing. This was the judge observing the violation in real time. The judge looking at the situation and the deference that the appellate courts have to give to trial courts is very real in this case, where the judge is observing this in real time. And this is not a situation, as we see in some of these other cases, where the violations happen outside of the courts.
But the court's order says the only reason he did this was to get in her litigious nature or character. And I could certainly look at it as she won't admit it's a permanent injury. There were probably answers to interrogatories or something else from the old other case where it said she made a claim for permanent injury. So there could be a legitimate reason in addition to an illegitimate reason.
I suppose.
And how the judge can, without hearing any testimony, decide or how he knows when he's looking at a piece of paper that he's being bad by looking at a piece of paper. I have some concerns about that. Overall, I mean, I'm one who agrees lawyers should behave well. They should obey the judge. If they have a problem, they take an appeal. But
I think what I would ask you to do, Judge, is go back and look at the beginning of the first day of trial when they discussed this motion, because the judge tells Mr. Olczyk how to get around what he needs. It's the same doctors. The same doctors treated her for the accident years ago. You can ask those doctors, did she have a permanent injury? Did she need future care? That's all he had to do. And he didn't want to do that. He wanted to get it in the way he wanted to get it in, which is to not obey the court's order. So he took a shot and it backfired is basically why we're here. And so if you don't have any other questions, I think I've addressed the points that I wanted to address. Happy to address
As to the letters or sending out the order to all the clients, was that outside the scope of his authority in this case?
I don't think there is a scope of authority unless there is something else that governs the sanction that's being administered, and that's where we look at the other cases that they rely on, which is basically taking away his law license, as Judge McIver pointed out, and that's not what we have in this particular. So there's no other governing, there's no other body that governs.
Kind of going back to the hearing issue, then wouldn't it be important to know whether this attorney has ever been sanctioned before, whether he's ever done this kind of conduct before, this is a first-time incident? Don't you think that's important?
Well, respectfully,
If you were, I know you said you've never done this, but if you were in his shoes, wouldn't you at least want that opportunity to argue that?
I don't think that it mattered to the court, and I don't think that it's.
I know it didn't matter to the court. That was pretty obvious, but
I'm
asking, is it appropriate to be able? That's one of the Cozell factors from the Florida Supreme Court, correct? That whether or not the attorney's ever been sanctioned before, that the court should review that.
Yes, if we're talking about striking pleadings, this is not a penalty directed to the defendant at all in this case. This is
right, but what difference does it make to the defendant if his or her lawyer has been a bad lawyer before and disobeyed orders before? That's not the client's fault unless the client knows he's hired a bad lawyer, right?
I
mean,
don't know
you look
that
at it to see what do we need to do to make this lawyer step in line. Is it fair, is it fair to strike his client's pleadings? Part of it is, if that was all it was, you go, what did the client have to do with this? And if the answer is nothing, why would you bother looking to see if the lawyer had been sanctioned before? I mean, I think it may not be determinative. I know it's two slightly different issues, but if it's important in one, how can it not be important in the other?
because we're talking about stripping a defendant's ability to defend itself or a plaintiff's ability to prosecute its claim. That's not what's happening in this particular case.
So you're trying to get clients not to hire him anymore, or trying to get him to reform, but by sending the letter out, you're essentially telling clients, watch out, this guy is a bad lawyer, you shouldn't be hiring him. Why else would the letters be going out?
Yeah, I mean, the judge says that in his orders. It's to make sure clients know that either he has performed poorly, or you could potentially be on the hook for sanctions yourself by allowing this behavior to continue in your own case.
It may be appropriate, again, with some of these lawyers whose names I haven't mentioned, but they're not hard to find, who repeatedly, I mean, their MO is if they don't like the way it's going, they get a mistrial. They intentionally get a mistrial. Here, whether it was an intentional mistrial, I don't know. Certainly he disobeyed the court's order. Whether the order was correct or not is not really an issue here today.
Right.
But if you've got a lawyer who, in the heat of the moment, made a very bad mistake, that's different than a lawyer who repeatedly does this. And how can the judge not take that into consideration?
I would just, in closing, Judge, I would just ask, and I just would wonder, if we had done this with those other attorneys earlier, would we have had these cases that we have, that the courts decided in those cases? So
there may be attorneys who made one mistake who'd be on welfare now because they're stripped of all their clients. Is that fair?
That's not what's going to happen in this case.
How do we know?
Well,
if the judge's sanction is effective, those clients who get the letter or got the letter or will get it in the future, the judge is saying, don't hire this guy. I mean, that's the long and the short of it. You shouldn't hire this guy.
Judge, when we make decisions that violate court orders, we have to be able to, or we have to appreciate the consequences that come along with them. And I'm not one to sit on this side of the bench and tell a judge what he should or shouldn't do when it comes to sitting there during trial and observing someone disobey his orders. That's ultimately your decision to decide whether he abused his discretion. We don't think that he did, and we would ask the court to affirm.
Okay, thank you.
Thank you.
Any other questions? Okay, thank you. Before you go into anything else, tell us if there was a request for an evidentiary hearing.
That was first on my list. We did ask for an evidentiary hearing twice. Once in the motion for reconsideration, that's on record page 1764, and again in the motion for rehearing, which is at record page 1984 through 2000. You asked opposing counsel if this was an intentional act, and I guess I would just reiterate that I don't think the record bears out that, based on the information you have in the record, there's no reasonable basis to say that it was intentional. But even if there might have been, there was no evidentiary hearing, so you can't make a factual finding like that without an evidentiary hearing. Mr. Olczyk, especially when part of the findings are based on the court's interpretation of the actions he saw Mr. Olczyk take, that the court never asked Mr. Olczyk to explain. As far as whether violation of the ruling, whether that determination is subject to de novo review or not, I would say it is. I cited cases in the briefing that weren't responded to in the reply brief, and they hold that whether a ruling was violated is subject to de novo review. And that determination is based on the language of the ruling. Just like we review statutes based on the language that's used, we should interpret the judge's ruling based on the language that he used. And but I understand the panel is inclined to find that there was a violation, so I won't belabor that point. But I'll just say that even if there was a violation, the sanction here was an abuse of discretion. Even if the court had the authority to issue the sanction, requiring Olczyk to send this letter out was far out of proportion to the conduct that happened. Moakley does not authorize a court to punish one attorney for the sins of all the other attorneys that have come before the court. The determination has to be individualized based on the conduct that happened before the court.
Going back to, I think, what was my first question, do you see Moakley as an authorization for what courts can do, or as a restriction on what the courts are inherently allowed to do?
I guess I would say I see it as both. When the Moakley court determined whether a trial court can order attorney's fees as sanctions, it answered that question by looking back at the case law to decide what is the source of this inherent authority. And it found old cases that said the source is the court's need to carry out its business. And so if a sanction can't be traced back to that need, then it's out of bounds. And again, I think it's important to remember that a court only has jurisdiction to deal with the cases in front of it, not to deal with all the clients of an attorney. And for these reasons and all those, was there another question?
Questions? Go ahead, sorry.
All those argued in the briefing, I asked for you to reverse and remand for vacation of the sanctions order. Thank you.
You want to take a short break?
I'm fine. If you want to go.
Take a break?
I'm fine, it's up to you.
All right, thank you very much. And we'll